Welcome back kapatid to our ongoing series on persons and family relations. In our last lesson, we began with the conflict of laws provisions of the Civil Code. We learned about Article 14 and the principle of generality and the principle of territoriality. We learned that our penal laws, our laws on public security and safety are binding not only to Filipinos who are living in the Philippines, but to everyone else who is staying here even temporarily. We also learned about the exceptions to these principles. For instances, when crimes committed abroad may be prosecuted here, or those who commit crimes here but may not be prosecuted here. In case you missed it, I'll be leaving a link to that in the description down below. Today, we're looking at Article 15 of the Civil Code, which provides that laws relating to family rights and duties or to the status, condition, and legal capacity of persons are binding upon citizens of the Philippines, even though living abroad. Article 15 of the Civil Code contains the nationality principle under conflict of laws. By the end of today's lesson, we should be able to, number 1, define family rights and duties and their sources. 2. Distinguish between status, condition, and legal capacity. 3. Correctly identify the applicable law given a conflict of law situation. All of this and more coming right up. Hi, my name is Lex and welcome to Lex in Motion. In this channel, I'll be helping you build your competence, confidence, and capability in law school. Start today by hitting the subscribe button below. New episodes are posted every Friday. Article 15 of the Civil Code provides us with the nationality principle. This means that the family rights and duties, the status, condition, and the legal capacity of persons are binding upon all Filipinos, even though they are living abroad. Pag-uusapan natin yan mamaya kapatid, pero unahin muna natin ano ba ang ibig sabihin ng batas sa family rights and duties, status, condition, at legal capacity. When it comes to family rights and duties, the most basic example is Article 194 of the Family Code, which provides that support comprises everything indispensable for sustenance, dwelling, clothing, medical attendance, education, and transportation in keeping with the financial capacity of the family. The education of the person entitled to be supported referred to in the preceding paragraph shall include his school or training for some profession, trade, or vocation, even beyond the age of majority. Transportation shall include expenses in going to and from school or to and from the place of work. Article 195 on the other hand imposes the duties enumerated under Article 194 of the Family Code upon the spouses, ang mag-asawa, legitimate ascendants and descendants, ang mga lolo at lola sa kanilang mga apo, and parents to their legitimate and illegitimate children. Mahaba-haba ang provisions ng Family Code pagdating sa support at excited akong pag-usapan natin yan kapatid sa mga susunod pa nating kwentuhan. Ang mahalaga lang na dapat nating matutunan ngayon ay mayroon tayong batas kung saan dapat suportahan ng isang magulang ang kanyang mga anak at ang mga lolo at lola sa kanilang mga apo. Correlating Article 15 of the Civil Code and Articles 194 and 195 of the Family Code, we can come to the conclusion that, number 1, the family rights and duties of a person is determined by his national law. 2. Support includes food, shelter, clothing, school, medical expenses, and transportation. Given these two statements, here is a problem. Si X ay isang Filipino seaman na matagal nang sumasampa sa barko. Noong 2015, nagpakasal siya sa kanyang kasintahan na si Y. Noong 2016, sila ay biniyayaan ng kambal na batang babae, si A at si B. Subalit noong 2018, nakilala ni X si Z, isa ring OFW na nakabase sa Taipei. Naging sila na ni X ilang linggo mula nung sila ay nagkakilala. Hindi na pinapadalhan ng sustento ni X si Y at ang kanilang kambal. Ano ngayon ang remedy ni Y laban kay X? We know that X is liable to support Y, A, and B. That much is very clear from Articles 194 and 195 of the Family Code. Our goal at this point is to get X to pay a fixed amount of money each month para sa mga pangangailangan ni Y at ng kambal. How can we hold him liable? What would be our legal basis? Our options as things stand is to file an action for support. We come to court to petition that Y, A, and B should be given a fixed monthly support in an amount to be determined by our courts. There are no fixed amounts set forth by law, but the guidelines are always based on the financial capacity of the person obliged to support and based on the needs of the person who is entitled to support. The way to enforce this, at pasensya na kapatid kung medyo nagiging remedial law na ang ating discussion, pero mahirap kasing aralin lang natin ang batas na para bang binasa lang natin. Mas maiintindihan natin ito kung practical ang approach at maipapakita natin kung paano umaandar ang mga rules na to to meet our goals. If the court holds X liable for the support of Y, A, and B, the court will issue an order against B where he is obliged to give a particular sum of money for the support of Y, A, and B. This judgment for support never achieves finality. It has to change from time to time. Maaaring ang 20,000 pesos kada buwan noong 2018 ay hindi na magiging sapat yan kapag ang kambal ay papasok na ng high school at college. Now kapatid, would your answer be the same if X is not a Filipino but instead he is a citizen of Netherlands, a Dutchman? Now kapatid, would your answer be the same if X is not a Filipino seaman kundi he is a citizen of Netherlands, a Dutchman? Would he still be liable to support his Filipina wife Y and their twin daughters A and B? In the case of Norma del Socorro versus Ernst Johann Brinkmann von Wilsem, the Dutchman in this case argued that he had no obligations to support their minor child under the law of Netherlands. To this, the Supreme Court applied the doctrine of processual presumption. The Supreme Court ruled that in view of respondent's failure to prove the national law of the Netherlands in his favor, the doctrine of processual presumption shall govern. Under this doctrine, if the foreign law involved is not properly pleaded and proved, our courts will presume that the foreign law is the same as our local or domestic or internal law. Thus, since the law of the Netherlands as regards the obligation to support has not been properly pleaded and proved in the instant case, it is presumed to be the same with Philippine law, which enforces the obligation of parents to support their children and penalizing the non-compliance therewith. Review na lang yung konsepto na yan kapatid dahil napag-usapan na rin natin yan sa mga naunang lesson. In case you missed it, I'll be leaving a link to that in the description down below. Article 15 also provides that the status and the condition of Filipinos are determined by our national laws. Status here means the sum total of a person's rights, duties, and capacities. It is a very broad term, kaya let's look at an example instead. One example of a status in civil law is paternity. Paternity is the status or relationship between a parent and a child. Although technically, maternity naman kung sa nanay, pero paternity lang ang ginamit na salita ng batas, which tells us about the condition of women in society, at least under our old laws. Paternity is a status of being a parent to a child. Alam natin kapatid na ang paternity sakop ang rights and duties at capacity. Sa ilalim ng paternity, may obligasyon ng isang magulang na suportahan ang kanyang anak. That's very clear under Articles 194 and 195 of the Family Code. Pasok din dito ang duty ng anak to respect his parent. Under the law on wills and succession, a parent by the status of paternity has the right and capacity to succeed from his child. Applying Article 15 of the Civil Code, we know that a person's status and condition, specifically paternity, is subject to the national law of a person. Now, under our laws, the status of a person is inalienable, imprescriptible, and cannot be the subject of compromise. This means that no matter how much you hate your child or your future children, hindi na pwedeng maalis sa kanila na anak mo sila. Hindi nyo pwedeng pagkasunduan na hindi mo na siya anak at hindi ka na niya magulang. That is the essence of the status of a person. Let's look at another status, filiation. This is the relationship or status that one person has of being a child to a parent. Same lang din yan kapatid, a child has a right to be supported by his or her parents. A child has the correlative duty to obey his or her parents. A child also has the capacity to succeed. Pwede siyang magmana o mapamanahan subject to certain limitations sa pagpanaw ng kanyang mga magulang. Finally, we have capacity. Capacity is a technical term in civil law and it is also the most important topic when it comes to persons. If you understand capacity, then you understand half of persons. This will be taken up once we reach Article 37 of the Civil Code, but let me just give you a broad overview. Legal capacity is divided into two parts. You have juridical capacity and the capacity to act. Article 37 of the Civil Code provides that juridical capacity is the fitness to be the subject of legal relations. It is inherent in every natural person and it is lost only through death. Juridical capacity, kapatid, ay ang ating kakayahang tumanggap o maging subject ng legal relations. Lahat ng tao ay may juridical capacity. Lahat ng juridical capacity natin ay pantay-pantay. Sa mga natural persons, so ang mga taong living things, kagaya mo, ang juridical capacity ay bahagi na ng ating pagkatao. Sa mga artificial persons or persons whose personality is created by law, like corporations, city governments, and partnerships, they begin to have juridical personality on the date they are created. That's the issuance of the Certificate of Registration and the Articles of Incorporation. For city governments, that's usually the date of their charters. On the other hand, we have capacity to act, the second half of the legal capacity under the Civil Code. Capacity to act is the active aspect of legal capacity. It is the ability to make actions with legally binding consequences. Unlike juridical capacity, capacity to act exists in varying degrees. Hindi ito pantay-pantay. According to Professor Balane, no person has 100% capacity to act. But we can come very, very close to it. Pinakamahusay na halimbawa sa capacity to act ay ang unborn fetus. Subject to certain conditions which we will discuss in future lessons, an unborn child can have the right to succeed. Pwedeng-pwede silang pamanahan kahit hindi pa sila isinisilang. The capacity to act of an unborn baby is very, very close to zero, but it is not zero. As a child grows older, pwede siyang bumili ng suka, ng toyo at ng patis. That is a contract of sale and that sale is valid, subject to certain conditions. Somewhere in the middle, you will have aliens in the Philippines who have the capacity to enter into contracts of lease. Pwede silang mangupahan ng apartment o ng condominium. Pwede silang bumili ng kotse, ng libro at pagkain. Pwede silang pumasok sa contract of employment but they cannot, at least at the time of this publication, own congressional franchises for public utilities. Towards the end of the spectrum, you have regular persons, Filipinos with full capacity to act. We can own land, buy houses, or sell them if we want to. Pwede tayong mangutang, magpautang, magsanla, at magbenta. Pwede tayong magpamana at pwede rin tayong mapamanahan. Pwede tayong maghabla, mahabla o maging testigo sa isang kaso. The capacity to contract a valid marriage is also part of the capacity to act. Combining the ability to be the subject of legal relations and the capacity to act on these legal relations, we now have legal capacity. Now going back to Article 15, we are Filipinos and we are in the Philippines. Applying Article 15, our legal capacity is always determined by our national law, Philippine law. Kahit pa tayo ay manirahan sa abroad. Kung tutuusin, madali lang intindihin ang Article 15, kapatid. Walang mahirap or particularly technical about this provision. Nagiging mahirap siya dahil sa application nito sa isang problem. Before we go into some cases and problems, let me point out, in the context of persons and family relations, madalas na itanong under Article 15 ay ang theories on personal law. There are two theories on personal law. The first is the nationality principle. This means that family rights and duties, the status, condition, and the capacity of a person is determined by his or her national law. The second is the domiciliary principle. This means that instead of the national law, we follow the law wherever the person may be domiciled. In the Philippines, we follow the nationality principle because of the express provision of Article 15. Under the domiciliary principle, the family rights and duties of a person, his status, condition, and capacity are determined by the law of his domicile. Domicile, kapatid, means the place of permanent residence. It is a technical term that you will encounter in constitutional law, election law, and later on in taxation. Domicile refers to the place where a person currently resides. In Romualdez versus Regional Trial Court and later on in Macalintal versus Comelec, the Supreme Court teaches us that domicile denotes a fixed permanent residence to which, when absent for business or pleasure or for like reasons, one intends to return. It is the combination of two elements, animus manendi or the intent to stay, and animus non revertendi or the intent to return. Domicile, kapatid, ay ang lugar na iyong itinuturing na bahay. It implies an element of permanence. If you are staying in Pasay City during weekdays at sa mga araw na may klase ka pero umuwi ka naman sa Bawan, Batangas tuwing weekends at dito ka rin na malagi ngayong ECQ, then it can be said that your domicile is in Bawan, Batangas. It is the place where if you leave for business or for pleasure, you intend to return to. Most importantly, it is the place you specifically call your home. As applied in conflict of laws problems, a German citizen is a national of Germany. If he stays in the Philippines for work, he is said to have moved his domicile in the Philippines. If he visits for business, then he is said to have his domicile still in Germany. The visit to the Philippines is merely temporary. He has no intention to stay, and Germany is still the place he intends to return to when his business in the Philippines concludes. We can stop here, kapatid, but I want to take it 2 or 3 steps further to complete your understanding of the nationality principle. Most of the problems here will move around marriage and the validity of a marriage or later on a divorce. So let's lay down the rules. Article 26 of the Family Code provides that all marriages solemnized outside the Philippines in accordance with laws in force in the country where they were solemnized and valid there as such shall also be valid in this country except those under Articles 35 Paragraph 1, Paragraph 4, Paragraph 5, Paragraph 6, Articles 36, 37, and 38. Where a marriage between a Filipino citizen and a foreigner is validly celebrated and a divorce is thereafter validly obtained abroad by the alien spouse, capacitating him or her to remarry, the Filipino spouse shall likewise have capacity to remarry under Philippine law. For our purposes, we will focus first on the general rule laid down by Article 26. Under Article 26, a marriage among Filipinos or between a Filipino and a foreigner, if it is valid in the place where it is celebrated, is valid under our laws. For example, we have A and B. They are Filipino men aged 35 and 32 respectively. Pumunta sila ng New York kung saan valid ang same-sex marriage. Doon sila nagpakasal. Umuwi sila ng Pilipinas 3 months thereafter. What is the status of their marriage? Applying Article 26, we have a marriage solemnized in New York and it is valid there as such. Is this marriage valid under Philippine law? The answer, kapatid, is no. Article 15 tells us that the legal capacity is binding upon the citizens of the Philippines even if living abroad. Article 1 of the Family Code requires that marriage is a special contract of permanent union between a man and a woman. In this case, both of them are Filipino men. Our laws currently prohibit same-sex marriage and I do hope this changes in the future. Pero sa ngayon, their marriage is void. Let's look at another example. Under Mexican law, it is possible for one of the parties to a valid marriage to be absent during the ceremony. This is called proxy marriage. One person can be represented by a messenger, by relatives, by an agent, or any other person nominated as a proxy. The only requirement the Mexican law further provides is that the marriage should not be celebrated in secret so that it can be proven later on. Now, here is Facundo, a dashing young man, matangos ang ilong, hasyendero daw siya at solong tagapagmana ng isang drug cartel. Assured ang future mo, bes, kung magpapaligaw ka sa kanya. He insists that you marry him and you say yes. Kaya lang nag-ECQ at hindi ka makaalis ng bansa. He now suggests that you marry him and you say yes dahil na rin siguro marupok ka. Assuming that your marriage to Facundo is valid under Mexican law, are you now legally married to Facundo by the strength of Philippine law? Tandaan kapatid, hindi ka nakaalis ng Pilipinas. So the question, are you now legally married to Facundo by the strength of Philippine law? The answer, it would appear, is that your marriage to Facundo is valid. Yan ang isa sa mga mali ko nung midterms namin almost 10 years ago. The correct answer is that given the facts as I have narrated them, the marriage would be recognized in the Philippines. A proxy marriage celebrated abroad, if it is valid there as such, can be given recognition in the Philippines. Your personal appearance in your wedding ceremony is not an essential requisite under Article 2 of the Family Code. If the marriage is valid in Mexico, then it should be given recognition in the Philippines in accordance to Paragraph 1 of Article 26 in relation to Articles 2 and 3 of the Family Code. The exceptions under Article 26 of the Family Code we will discuss more as we tackle family relations. For now, kapatid, I want you to turn your attention to Paragraph 2 of Article 26 of the Family Code. This is a very powerful provision, kapatid. Once upon a time, foreigners were allowed to marry Filipinas either here in the Philippines or elsewhere in the world. If the marriage does not last, these foreigners are able to marry again. But before we had Paragraph 2 of Article 26 of the Family Code, these Filipinas could not marry again. This is because in the Philippines, we have no law on absolute divorces. The only way a marriage is dissolved is through death, through the declaration of nullity of marriage, or under annulment under Article 36 of the Family Code. Kahit na wala na sila ng foreigner at nakapag-asawa na ang foreigner, ang Filipina na umuwi sa Pilipinas ay hindi makakapag-asawa because under Philippine law, she is technically still married to the foreigner. Mabuti naman, many years later, we now have the recognition of divorces obtained abroad under Paragraph 2 of Article 26 of the Family Code. Here are the rules when it comes to divorces in the Philippines. This, kapatid, is the most important part of today's lesson and I encourage you to write this down. Number 1, between a Filipino and a Filipina who marry here in the Philippines, there can be no divorce. That's our present law, at least at the time of the publication of this video. Number 2, a foreigner and a Filipina who marry in the Philippines but obtain the decree of divorce abroad are divorced according to Philippine law, so long as the divorce decree is recognized in the Philippines. 3. In order for the Filipino spouse to marry again, the divorce decree must necessarily capacitate him or her to marry again. 4. The existence of the divorce decree and the foreign law on divorce, in order for them to be given recognition in the Philippines, must be pleaded and proved in accordance to our rules of evidence. 5. It is no longer important if the divorce decree was obtained by the foreigner, by the Filipino spouse, or both. The last of these rules was given to us by the Supreme Court in the case of Minoru Takahashi and Juliet Moranya versus Republic of the Philippines. This case was decided on December 5, 2019 and it might not yet be present in the textbooks you will buy. This case is a must-read and will be part of the quiz. To summarize today's lesson, number 1, Article 15 of the Civil Code lays down for us the nationality principle. This is distinguished from the domiciliary principle, which provides that the family rights and duties, status, condition, and legal capacity is determined by the law of the place of his domicile. 2. The primary source of family rights and duties in the Philippines is the family code. Status is the combination of the rights, duties, condition, and capacity of a person. 3. Legal capacity is the combination of juridical capacity or the capacity of being the subject of rights and duties and the capacity to act, which is the ability to take action on these rights and duties. 4. Domicile is the place of permanent residence. It requires animus manendi, the intent to stay, and animus non revertendi, or the intent to return. For the cases on foreign divorce under Article 26 of the Family Code, I will be leaving a list of cases for you to read to better appreciate the nationality principle and its application in the context of conflict of laws. Pasensya na kapatid at napahaba ang lesson natin. The next few lessons are going to be more and more technical, and to be honest, may mga law students na sa bar review pa lang nila ito naiintindihan. I have done my best to make this as simple as possible. If this approach is working for you and you would like us to continue these lessons, please type yes in the comments down below. Today's quiz is going to be a little longer than usual dahil marami tayong na-cover. Choose only true if the statement is true, complete, and admits of no exceptions. Choose false if the statement is really incorrect. Choose there are exceptions if you feel that the statement admits of exceptions. Please, please, please do not discuss the question so as not to spoil the quiz for those who will watch later. Finally, please post your scores in the comment section. I am very happy to see your scores because it helps me keep track of your improvement and progression. Thank you so much for watching. Like and share this video for good law school karma, and I will see you next Friday.